Assalamualaikum. My name is Karuna Jiha bin Kamaruddin. Metric number 257140. So today I would like to do introduction about ADR. ADR is known as settlement out of court. It consists of mediation, conciliation, and arbitration. Arbitration requires an arbitrators or panel. It can be one or more, and decision made in arbitration will be called an award. And under arbitration, there is two types of arbitration, which is interstate arbitration, also international commercial arbitration.
Good day, Dr. Hanisham and my fellow friends. As you can see my details here, I would like to move on with our presentation. Sources of law in addressing international commercial arbitration. There are two scenarios. First, the parties at dispute at their free own will had chosen such choice of law to be used whenever there is a dispute. I would like to quote the case of James Miller here. Lord Reid had strengthened that in absence of such express agreement clause, the contract should be read in entirety to find out the intention of the parties on which choice of law should be used. The second scenario, in absence of such choice of law, the burden now lays on the arbitrators. The arbitrators can use two approaches. First is an lex fori approach, whereby an established set of rules of general principles or a national law can be used. The second one is a delocalized principle, whereby rules and regulations from international conventions can be used to address the disputes. With this, thank you.
Good day, my name is Soon Yong, 253540. So, for the seat of arbitration, it is defined as a jurisdiction in which the arbitration carries out legally. So, it is very important because we have to choose which law to be applicable in our arbitration agreement. So, according to the Article 20, Clause 2 of Model Law, the arbitral tribunal may meet any place appropriate when both parties agree. So, this is a case can be referred. So next to the qualification of arbitrator, the arbitrator can be defined as a person who decides the underlying dispute between the parties. So he is chosen by both parties. His qualification can be a physical person having legal capacity and non-professional skill like the common sense ability to make independent judgment. So I'll pass it to the next presenter.
Outstretching 25238. Next, I'll move the binding effect of interim and final award in arbitrations. Final award means final decisions given by the tribunals and the arbitrators become functions of officials, while interim award is a temporary award until the tribunals have given its final decisions. Basically, under arbitrations, it cannot be appealed to a higher level court because the award is final and binding upon the party which has res judicata effect. However, it may be appealed in some occasional opportunities, such as some defects in the process or where the arbitrators have acted out trial virus. The most common method to challenge the award is to set aside a vacate in the court at the status of the arbitrations. It will be the crucial law governing all these actions. Different states has different grounds to challenge the award. For example, under English Arbitration Act 1996, the party may make appeal based on serious irregularity which affect the tribunals the proceeding of the award. Next, enforcement and recognition of award is very important as it makes the award has an official legal status. And the successful parties is required to start the enforcement if the losing party refuses to comply with, and it can be only carried out through the national court. And there are few grounds granted to refuse recognition and enforcement, such as incapacity of the party to enter into the arbitration agreement, or there's no proper notice of appointment of arbitrators. Thank you.
Arbitration versus mediation. Arbitration, according to a convention of 1899, it is a settlement of differences between states by judges of their choice. According to Section 806 of Italian Code of Civil Procedure, the parties can appoint arbitrators, or they may allow the court to appoint one for them. This was illustrated in the case of Jivraj and Hashwani, where the arbitration provision that is part of the agreement is considered null and void by the court because of religious grounds. Mediation, on the other hand, is a formal procedure whereby two or more parties to a dispute seek to reach an agreement to the dispute. Usually they are assisted by a third party that is impartial called a mediator. This was defined as a transactional arrangement by the Section 1965 of the Italian Civil Code, because at the end of the mediation, the objective is to reach a win-win win-win situation for the both of them, and therefore no consent is obtained. That's all from me. Thank you.
Hi, my name is Annie Remigius Sulaiman. My metric number is 253490. In my part, I will make three comparisons between the arbitration and the conciliation. The first distinction is the effect of the party invitation. In the conciliation, the invited party may accept or reject because it has no binding effect at all. Meanwhile, in the arbitration, it becomes binding if there is prior written agreement. In the case of Grand Electrical Company Limited, the court held that the arbitration should not be treated as a choice if it is clearly stated in a contract. The second distinction is the role of the third party itself. In the conciliation, the third party helps and assists the parties. Meanwhile, in the arbitration, there is the addition of the roles as the arbitrator arbitrates and resolves the dispute through an arbitral award. In the case of Evergrande Construction Company Limited, the court implicitly highlighted that the arbitrator also seek the parties' views or consult them. Meanwhile, in the third distinction is the process itself. The arbitration has a formal process, meanwhile the conciliation has an informal process because the arbitration somehow may follow similar procedures to court proceedings. And another thing is there is a guaranteed decision in the arbitration through the arbitral award. Meanwhile, in the conciliation, it may be not guaranteed.
So, for the conclusion, arbitration has been used extensively in solving international commercial disputes, and arbitration used to prevail over another alternative. Arbitration also became one of the pertinent methods utilized by most states, and also the flexibility and comprehensive of arbitration has brought greater relief for the disputants.